Still good morning. It's only 11:30. Welcome. My name is Mary Vick. I am the support service manager here at the Alzheimer Group Inc. For those who are joining us for the first time, here is a little background about us. Alzheimer Group is a charitable organization that supports families and individuals living with dementia. Our services include activities for people living with dementia, individual and family counseling, support groups for caregivers, and courses, workshops, and webinars. Our educational initiatives are made possible by the generous support of the Lassner Learning Center and the Lindsay Memorial Foundation. Before we begin, please note that while the chat feature is unavailable, there is a Q&A button space for you to ask your questions. You may type your questions at any time throughout the presentation, and we will try to address them during or after the presentation. Today, we are pleased to welcome Nada Chalaby. Did I pronounce it correctly? Okay. Nada is a dedicated and experienced notary for over 10 years, passionate about providing essential legal services to individuals and families during crucial moments. Her expertise lies in wills, protection mandates, estate settlements, homologation and protection mandates, tutorships for minors and incapacitated adults. With an enthusiasm for helping individuals and families plan for the future and navigate the legal intricacies of these critical documents, Nada prides herself in offering a personalized and comprehensive service. Welcome, Nada. I pass the room to you.
Thank you. Hi, everyone. So I will be talking about tutorship to a person of full age. So tutorships is basically if you don't have a protection mandate and it is unfortunately too late to sign a document, then we would require a tutorship to be put in place instead of homologating a mandate of protection. So what is a tutorship? It's basically a legal measure aimed at ensuring the protection of the person, the administration of their patrimony, and the exercise of their rights. It is basically where, in the event of a person's incapacity and when they require representation in exercise of their rights. There's two sort of tutorships. There's a tutorship to the property and tutorship to the person. The tutorship to the property is basically only for the administration of their patrimony, and the tutorship to the person is only for the protection of their person. So their well-being, the representation in the exercise of their civil rights, and the defense of their rights. And the tutorship can be for both, so tutorship to the person and tutorship to the property. I would say that usually what I see is both, so to the property and to the person. So who starts the process? Who initiates the process? It would be the person concerned or their spouse, a family member, a friend, or someone who shows an interest in them, okay? The first step before a notary can even start the process with the court would be to obtain the medical and psychosocial assessments. So the medical assessment will be done by a physician, and a psychosocial assessment is done by a social worker. The second step would be to actually file the application to start the tutorship. I would say it's with the court or with a notary. So a notary has to be certified in tutorships and homologations of mandates to actually do it from A to Z. Some notaries aren't. I am, for example, and they go and proceed with the court. I would say that with the court, it's usually longer and more expensive. So that's why I took the measure to actually take the course and be certified in tutorships and homologation of mandates through a notary only. So that would be the first step. The second step would be to file the application with a notary, and it would be obviously accompanied by the medical and psychosocial assessments. The third step would be to interview the person concerned. So it's basically to determine the person's incapacity and to obtain their opinion on actually opening the tutorship and on the person who will act as their tutor. Because unlike the mandate of protection, where there is a document stating who will be the tutor, the tutorship doesn't, right? There's no document prior that the person concerned wrote, oh, I want this person to be my tutor. This actually just happens, and it's basically family members who decide who the tutor is. I'll get back to this in a few slides. So at this point, the person can contest the application for a tutorship, and anyone in the family can contest as well. It doesn't happen a lot, but it does happen. Some people contest who the tutor will be, and they want someone else to do the job, if you want. And so the fourth step would be to have a meeting of the relatives, the persons, the people connected by marriage or civil unions, and friends. So it's any family members and friends who show an interest to the person concerned, and there's a meeting basically to talk to them about the tutorship. Okay, so it's just an opportunity for everyone to express their views on the tutorship, the choice of tutor, and the members of the tutorship council. So the tutorship council is 3 people that constitute the tutorship council. It is also chosen by all the family. So there's 3 people who are part of the tutorship council. Usually we ask for 2 substitutes in case one of the members cannot act, a tutor and a replacement tutor. And then the final step would be to have the court decision. So a judgment is granted and sent to the notary. So it usually takes about 6 months, I would say, from the application, from the first application done with the notary. It takes about 6 months. Unfortunately, it's been like that for years. The courts are very backed up, so it does take about 6 months. I wanted to have just a small talk about the reassessments. The medical and psychosocial needs to have reassessment. So the person concerned needs to be reassessed by the physician and the social worker. Usually it's between 5 and 10 years. So the person under the tutorship still has the exercise of some rights. So I would say that they have the right to participate in decisions that concern them, and they can express their wishes. They have the right to be consulted on any decisions made on their behalf. They have the right to live in the same economic conditions as prior to the tutorship. And they have the right to a reassessment of their incapacity. And they also have the right to have their tutor replaced. They can express their wish on who the tutor will be. So before I continue, I just want to make sure if there's any questions before I continue on with the roles and responsibilities of the tutor.
So far, I don't have anything, but I have one question, Nada, that I wasn't really clear for me. Like, so protective mandates, you do it like prior, right? And then, like, once the person is incapacitated, like established incapacitated, then you go through homologation.
Yes.
Tutorship, you said, is like if there's no protective mandates, but still you need to reassess the person's capacity one way or the other, right?
Right.
That's
Yeah.
what you were saying. Okay. Okay. I just wanted it to be clear. Yeah.
No
Thank
problem.
you.
So roles and responsibilities of the tutor to the person. So if you are acting as a tutor to the person and to the to their patrimony as well. I'll get back to this is the next slide. So to the person, you basically have the responsibility to ensure the well-being of the person. Their moral well-being, you will need to defend their rights, to assist them or represent them in making any decision, to maintain a personal relationship with them, to consent or refuse care on their behalf, and to be reassessed as well. You also have to submit a rendering of accounts to the tutorship council and to the public curator. So on a yearly basis, the tutor has to render accounts to the tutorship council and to the public curator. The responsibilities of the tutor to the property, it's basically you have to manage the person's patrimony and ensure the value is maintained. There's certain obligations, such as making an inventory to the person's patrimony, and this has to be done within 60 days of the opening of the tutorship, and it has to be submitted to the tutorship council and to the public curator. The tutor to the property also has to provide a security, so it's basically a guarantee that protects the person's patrimony, and this only applies if the value of the patrimony of the person concerned is over $40,000. And you have to keep your personal assets and income separate from those of the represented person. You cannot use your personal accounts to manage their patrimony. And same thing for the tutor to the person. You have to submit a rendering of accounts on your administration on a yearly basis to the tutorship council and to the public curator. Now, the roles and responsibilities of the tutorship council. As I mentioned, the tutorship council has to be composed of 3 people, and there's 2 substitutes as well. They basically act in the interest of the represented person, and they monitor the tutor's administration of the person's patrimony. So all the income, the expenses, the investments, they have to monitor it on a yearly basis. And they have to ensure that the tutor is acting in the person's best interest. And the same thing, they have to ensure that the tutor is looking after the person's well-being and taking actions to defend their rights. So the tutorship council basically verifies what the tutor is doing. In the tutorship council, there is a secretary that has to be named as well in the meeting that is set up by the notary. They're responsible for taking the minutes of the tutorship council meetings and for keeping all documents. So the tutorship council has to meet on a yearly basis, and basically the secretary is there to take down the minutes of those meetings and to keep all the documents. At the end of the tutorship, the documents must be given to the person who was under tutorship or their heirs if they are deceased. So I wanted to talk about the public curator in tutorships. So first of all, private tutorship is when someone other than the public curator acts as the tutor. This is often the case. It doesn't happen a lot where the public curator is the tutor. So the public curator informs the tutor of the rules that concern them. They support and assist the tutorship council and the tutor in performing their duties, and they provide them with the necessary documentation. So they usually receive by mail all the documents that basically mention all the roles and responsibilities of the tutor and of the tutorship council. They oversee the tutor's administration with the tutorship council. As I mentioned, the tutor has to render accounts on a yearly basis to the public curator and the tutorship council. They receive the inventory produced by the tutor. They verify the tutor's annual administration report. They determine the security if it wasn't already done. And they assume the role of tutorship council when the people close to the person are unable to do so. Okay, so they can act in the tutorship council if the members cannot do so. The public curator also holds a public register of all the tutorships. So they are aware of who the person, all the people concerned are that are under tutorships, and their legal representative as well. They also have the power to audit the tutor's administration in case of suspected financial abuses or potential harm to the person or to their property. And they deal with any reports because anyone can report the administration of the tutor. If they see that the tutor is not doing a good job, if there's a financial abuse, anyone can report it to the public curator, and then they have the power to investigate what's going on. And the public curator can also ask that the tutor be replaced if they're no longer able to perform their duties or if they're not fulfilling their obligations. And that's why there's in the meeting that is set up by the notary, there is a replacement tutor that is set up. That's it for me. You're muted.
Okay. So
I just wanted to you know, have it a bit have a bit of time to answer the questions, because maybe there's a lot of questions and we can go back on some points that I mentioned.
okay. So for the audience, please write your questions on the Q&A button. It's right there located at the bottom of your screen. Please feel free to write your questions. Nada, I just wanted to, for people with dementia, right? I mean, most of the time people, for those who have protective mandates, they do the homologation. So because they know that the person can no longer,
Express themselves.
Exactly. So how does it work with tutorship? Because I know you mentioned that there's I feel like I wasn't clear about a back and forth that people are still being asked. So where is the line, in terms of really for the tutor to make the decision for the person? Is my question clear? Yeah.
What do you mean? So if there's a tutorship and then there's a tutor?
Yes. Mm-hmm. Yeah. I mean, for the homologation, right? I mean, the person who has the mandatory given, right? They can make the decision for the person as soon as the court has it. So it's the same thing with the tutorship.
Same thing. So the family meets. I might have mentioned, there's a meeting of family and friends, and then they would choose who the tutor is.
Okay.
And the tutor would make all the decisions.
Okay. Okay.
Yeah.
And then in the council, though, one is, I just want to clarify, one is
Yeah.
the public curator. The,
No,
oh, no? Okay.
no, the public curator only acts if members of the tutorship council are no longer can no longer do so. So in the
Okay.
tutorship council, there's 3 members,
Okay.
and in those members, there's a secretary.
Mm-hmm.
Okay? And usually we ask for 2 substitutes in case one of them is incapable, one of them dies. So we
Mm-hmm.
so we always ask for 2 substitutes. And there's the tutor, who is not part of the tutorship council, and the
Mm-hmm.
replacement tutor as well.
Okay. Okay.
So that is
And
all discussed in the meeting.
okay. So who decides who will be on the tutorship council?
They do, the family
The
does.
family? Okay, the
Yeah.
family does.
Yeah.
Okay. Okay. I have a question. If a person has no living family in Montreal, but their one relative who lives in the United States has requested tutorship for the family member who no longer can make decisions for themselves, who is appointed in Montreal to oversee, this case has a social worker on file. So,
There's
anyway.
if there's absolutely no one, no family, no friends,
Mhm.
no one except one person in the US.
Mhm. Yeah.
It would be the public curator then.
Okay.
Unfortunately, it would be the public curator, or, if there's really, really no one, like, it can be a friend, it can be a family friend, then it would be the public curator. If there's really no one, that's the case where really there's no one for the person, then the public curator has to
Curators.
take over. Yeah.
Okay, steps in. How about like, I mean, for families, I guess it's the same thing if the family doesn't wanna, is not interested or doesn't wanna step in,
Right.
right?
Yeah, right.
So the case is brought to public curatorship.
Yes.
Okay.
Yeah.
You mentioned as well in the beginning, Nada, about like your credentials. So it makes the process a little shorter than if you go to a notary that is how do you say this?
Yeah, a notary or a lawyer that does it with the court. So
Okay.
because now the court has to get involved, and the court has to interview the person concerned, and the court has to do the family meetings, and they're already so backed up.
So, but if they go to you, then it's like shorter. The amount of
Yes,
time that is being processed is
yes,
shorter, but
yes.
it's still going to be there's still going to be a court hearing or no?
No, not even. There's
Not
no court.
even.
If it's done with a notary, there's no court hearing. If it's done with a court, then yeah, there is a court hearing.
So correct me if I'm wrong. Basically, because of you have to take extra credentials, you're able to set this, the tutorship council with the family and everything, and then can make decision without going to the court. Is that my
Exactly.
Okay,
Yes.
perfect.
Yes,
Okay.
but I have to submit the documents, my final documents, to the court,
Okay.
because everything is just registered there, and as well at the public curator, because as I mentioned, public curator has all the register of all the tutorships.
Okay. So I have one question in here.
Yeah.
Is it one person who is always the tutor of property and well-being, or
Okay, so yes, so usually there's a tutor to the person and to the property, but the family in the meeting can discuss and can say that one person is the tutor to the property and one person is the tutor to the person.
okay?
It can be different as well.
But
And
it can be one. It could be
and it
different.
can be one. It can be one who does both, and it can be one who does one and one who does another.
Okay. So, Nada, can you just give us again like a short summary of the whole process? So you let's say a family, like there's no protective mandate. There's a sure it's obvious that they're not able to make sound decision for themselves, and that's when
Right.
they request.
So we do first we have to do a mandate search as well, because we never know. Some people don't even know that
person.
their loved one did a mandate.
Okay.
We do a mandate search, and then we do the medical. The family has to do the medical assessment through a physician and a psychosocial assessment through a social worker.
Okay.
Then we open the file. There is the interview that has to be done. So I usually go in person, and I go see the person concerned. There is also a family meeting where we discuss, who will be the tutor, the tutorship council, the secretary, the replacement tutor, the replacements to the members of the tutorship council. And and then I basically have to submit a lot of documents at the court, draft a few documents. I know I'll leave out the boring paperwork.
Yeah, okay.
And then we receive a judgment from the court.
Okay. Another question about like the tutorship for property, only when the person has, you said like an estimated 40,000 and more, right?
No, there's the tutorship to the property is it has to be a tutor to the property is there even if it's less than $40,000.
Okay.
But when there's a certain amount, like $40,000, then you have to. There's certain rules that the court, like for example, if they need to sell a home, for example. So I've seen this a lot. They have to sell a home. Still, even if there is a tutorship in place, we need to ask permission to the court to sell that because it's over $40,000.
Oh, okay. Okay,
But when someone did a mandate, that doesn't apply. We don't have to ask permission to the court. So there is for sure an advantage in doing a mandate.
A mandate. Okay, so that's clear. So if it's only a tutor, let's say if the person has property, you still have to ask the court for the if they are able to sell the property. So which is different from the mandate, as you said. If they're the mandatory, they can just like go ahead and sell it without asking the court or something.
Yeah, exactly.
Okay.
Yeah.
Okay. I have a question, but it kind of like went out of my head. But I mean, it's good to know that these are the things that can be done, especially like for some, I guess for some of us, we don't have a protective mandate. So it's good to start thinking about it, right?
Yeah, for sure. Yeah, it's really good because when you do have a protection mandate, first, like I mentioned, you don't have to ask the court permission to sell a property, for example. And you choose yourself who the tutor will be. So there's, you don't have to have the family meeting. It's you wrote it in a document and it's chosen.
Okay, it's chosen for you. So it's I see the difference now.
Yeah.
So it is really advantageous to actually get yourself a protective mandate.
Yeah, for sure.
Yeah. So I mean, and then I guess I just want to clarify, this is the reason why you have how do you say this? Sorry, substitute as well, just in case the tutor is not able to perform what they're supposed to do.
Yeah, and in the mandate as well, you can choose when you go see a notary and you do the mandate. There's the main one that you choose, and then there's a substitute that you choose as well in that document in case the main one cannot or is unable to do it.
Okay, so another question in here, Nada. I take care of my husband's banking online, and so far I take care of his investments and mine with a financial person. We have wills and mandates and leave each other our assets to each other if one dies. In our wills, we have named our son to take care of everything if we both pass away. Now I am worried if something happens to me, my husband cannot take care of anything. Can my son take over if he has all the account numbers? Or what should I do in case I die before my husband? So I assume the husband is the one who is has
Hold on.
incapacity. Yeah.
Maureen, if something happens to me, my husband cannot take care. Um, Okay, so in the mandate, it depends what's in the mandate, right? So in the mandate, maybe the husband, it was only it was the power was given to the wife, right?
Mm-hmm.
Then we'd have to check in the mandate if the substitute is the son. So if something happens to the wife and
Mm-hmm.
the husband cannot take care of anything, then the son would be able to only if in the mandate it is him the substitute. So
Okay.
I would go check in the mandate and see who is the substitute. And if there's no substitute, then I would suggest to
Put
do
the substitute.
to do another mandate that mentions that the son is the substitute.
Okay. Okay. That's really so. I guess on both accounts, both the protective mandates and the tutorship, you require to have a substitute person, a second person,
Yeah.
just in case the first person cannot
Yes.
do their responsibility or what they're asked for
Right.
as
Right.
mandatory and as tutors. Okay.
Yeah. So I
Okay.
would check in that mandate who is the substitute.
Okay, okay. So it's again, like I mean, what I get from this is that like you need to have a protective mandate so
Yeah.
that it makes it less complicated for people who how do you say this, who's gonna like take over
Yes.
for you
Yes.
in the case that you can no longer
No. Yeah,
make
because
decision for yourself.
it's already written in the mandate. Who is the tutor, who is the substitute, and that's it. In the tutorship, unfortunately, the family has to meet and decide who the tutor will be, who the substitute will be.
Mhm.
There's a tutorship council that adds up. Um,
Another
yeah,
layer, yeah.
yeah.
So, oh, actually, I have a question. So, let's say they do have, you set your tutor council, but in the process, like, some disagreements, as we know with families, another family contests the decision. What happens?
If someone contests the
Yeah.
decision, so first of all, it has to be contested before the notary submits everything to the court. So it has to be
Okay.
done while in the process of.
Okay.
And if there is a contestation, then unfortunately, lawyers have to be involved.
Oh, okay.
And
Okay.
it's more time, more money. So yeah.
So basically, what you're saying, you can't contest after you have submitted all the requirements, all the
No.
documents, and everything.
No, you can't contest after the tutor has been chosen.
Okay. Okay.
But anyone can contest, and if they do want to contest, they have to take a lawyer.
Okay. So again, going back though, tutorship will only takes place if there is incapacity.
Yes,
Yeah,
I'm looking
okay.
at the question.
Yeah.
Is the tutor who is deciding things, or does the council decide? No, it's the tutor who decides, and the council verifies on what the tutor is doing. And if they see that they're not, if the council, if the member, one of the members of the council see that the tutor is not carrying out his roles and responsibilities and obligations towards the person, then they can call the public curator, and the public curator will investigate.
So
But it's a tutor who is deciding.
okay, so the tutor meeting that is done every year is it's the tutor council together with the notary, or is this just like the
No.
tutor council?
No, it's the tutorship council who meets on a yearly basis.
And then
They verify what the tutor's administration is. You know,
Okay.
all the expenses, the investments, if they did a correct
Okay.
job, basically. Yeah.
I know it's like a lot of layers, but I think it makes me feel reassured that these are things are taken into consideration just to make sure that the person under the tutorship is actually taken care of. I know it's a lot,
Yeah.
hassle, but
Yeah.
it's a for me, I feel like it's a good it's a good security measurement in terms of
Right.
like, yeah. Okay.
Yeah.
So we have your Yeah,
Yeah.
you can, yeah.
Yeah, what happens if a person concern if a concerned person gets married after diagnosis and there is already a mandate in place? Does the mandate yes, the mandate has to get respected for
Okay.
sure. Yeah.
Okay. Like especially for dementia, right? Like,
Yeah, whatever the person signed the mandate, it has to be respected. And then if the wife, the wife later on wants to contest, they can contest and they can say, you know what, I want to be the tutor, and so on and so on. Or if, maybe the tutor that's in place in the mandate doesn't want to do it, or says, it's fine, I don't want to do it, the wife can do it, then it's fine, everyone is in agreement, and we can proceed with a tutorship, and the wife will be the tutor. But usually the mandate has to be respected.
respect. Okay, so can it, because I think what I'm seeing here, like let's say for a person with the diagnosis of dementia, in the earlier stages, they still have like a lot of capacities, right? That they can
Yeah.
make decisions and everything. So, would you recommend that if this is the case as early on, they could still change the
Yes,
mandate, right?
yes,
So,
yes,
okay.
yes.
So
It's
that
always the
would,
last mandate that the person did that is valid.
yeah, despite the diagnosis, let's just say, right?
Yeah,
That if it
yeah,
is a dementia diagnosis and if they're still early on the disease, they could still change the mandate. Okay.
yes, yes.
Okay.
So is the tutor paid? No, the tutor is not paid, but they are allowed to get the reimbursement for, any, let's say they have to go on a trip for some reason for the tutor, then they get reimbursed their expenses,
Okay.
but they're not paid. They can get reimbursed their whatever they pay out of their pocket for the person concerned, but they're not paid as such. No.
Yeah, because it's not a job, right? Yeah,
Exactly.
it's
Yeah.
not like okay.
And usually it's the family, it's usually the family, the spouse or the kids who do it. So, and no, so they don't get paid, but they
Yeah.
get, as I mentioned, they get reimbursed for their expenses they incur.
Okay. So
Uh,
we
yeah. If your mandate says your son is the person to take over, if you both die, but if it's just the husband who has the dementia, I presume you have to add that this happens.
or should you homologate the mandate is changed so above is clear. Um,
I didn't
well, I
understand.
guess this is in relation to the first question, the prior question, right? They're both mandatories for each other. Like
Okay.
let's say if something happens to her, he's gonna be the person to make the decision. If vice versa,
Right. So if
yeah,
both, yeah,
yeah.
so if one of them dies,
Mm-hmm. But
and
the
then
husband, I think, is but it's just the husband who has the
oh no,
dementia.
I understand. It's the son and the wife who die.
Yeah. Uh,
Yeah, I think so.
mm-hmm, mm-hmm.
So if the son and the wife dies, and they're both named in the mandate,
Mm-hmm.
um,
Yeah. I think basically if let's just say like you're both mandatories as a couple, right? To each other, and then the person get diagnosed with dementia and the person who is the other one who is healthy passed away, then that's
it's
why
a
we said
substitute.
you need to have a substitute. Like
And
this.
then okay, and then if the substitute, so you homologate the mandate,
Mm-hmm.
the son,
Mm-hmm.
who is the main mandator,
Mm-hmm.
and then if the son dies, I think that's what she meant. If the son dies, then if there's no other substitute in the
Mm-hmm.
mandate,
Mm-hmm.
then a tutorship has to be opened because
Okay.
there's no longer any substitute,
Okay.
right? So
So,
that usually that's why I suggest to my clients to have the main in the mandate, the main one,
mhm.
and one substitute and another substitute.
Okay,
If
so there's like
in
two.
case, yeah, it's better to be covered,
Mm-hmm.
because, example, if the son dies and he's the substitute, then there's no one else to take over, then the tutorship has to be open.
Okay.
But usually if you plan two substitutes, then you're better covered.
Okay. So now I guess I'm just like curious about this situation because like again, as I've said, they're both mandatories to each other. The other person is diagnosed with dementia. So
Right.
technically, let's say if they're in the earlier stages, it doesn't really count for at the moment because both can make decision despite the diagnosis. But in the process, let's say that the person declined to a point that they can no longer make decision. In the main mandatory, let's say the wife, let's say, unfortunately, also became incapacitated. But as
Right.
long as they named their son as the second substitute, the substitute mandatory, then he can act on it as the, okay, when doing the homologation. Okay, perfect.
Yeah,
Yeah,
exactly.
yeah,
Yeah.
okay, okay. Okay, so she said they have
Oh,
two other
oh no, the
substitutes.
son is not dead.
Yeah,
Okay.
mm-hmm.
Okay, so that's good. Okay.
Okay, yeah. No, I mean, right now on my end, I think it's clear for me how homologation works and how tutorship works, a protective mandate works, I feel reassured that I could give them a little bit of a how do you say this, an explanation.
Right.
But I could always refer them to you, Nada,
Yes, of course, of
if they
course.
need to.
Yes.
And you have right there your
Yeah, my name, my phone number, and my email.
exactly. And you can also, because we have also Nada's phone number and email, so you can, if you need it, they can also contact AGI. So
Wait,
let's
there's
say,
someone then
yeah, yeah.
if a mandate was drafted years ago but not signed, does it carry any weight? No, unfortunately, it has to be signed. If dementia gets too far and it's too late, yeah, the only choice would be tutorship.
Tutorship. Exactly. Yeah. Okay. But again, you have to like, I mean, we have to, again, like it really is like you need not just any notary, but a notary that has credentials when it comes to
Yes,
tutorship and homologation, because it
yes.
just cuts the process like,
Yeah, to
yeah,
carry it
whatever. Yeah.
like alone, like not through the court, and yeah.
Yeah. Anyway, so Nada, thank you very much for
Thank
your
you.
time and for answering our questions and for really clarifying the difference between the two. And really, I think it will really direct our clients on the decisions that they're gonna make. Oh, I sorry, as I was saying,
Another question or?
yeah, where is your office, Nada? Basically,
Oh, it's in the West Island in Kirkland. But I do, I have clients all over Montreal and Laval, and so I can go to the
anywhere.
clients. Yeah,
Okay, as long as it's not on the other side of the globe, right?
exactly.
Anyway, again, thank you very much. Have a lovely rainy afternoon. And again, Nada, thank you very much. We really do appreciate this.
Thank you. Have a good
Okay,
rest of the afternoon.
bye.
Bye.